Hello everyone and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer. The employment of foreign nationals has become one of the most contested issues in South Africa's labour market. Against a backdrop of rising anti-immigration sentiment and renewed debate around the employment of foreign academics, we explore the legal framework governing the employment of lawful migrant workers in South Africa. In this episode, we explain the status of lawful migrant workers, permanent residents, and naturalized citizens. We also consider the proposed amendments to the Employment Services Act, which represents a significant shift in the regulation of migrant workers. Finally, we look at the unfolding national debate concerning the employment of foreign academics in South African higher education institutions, and we examine whether restricting the employment of foreign academics is consistent with the objectives of higher education, particularly the pursuit of internationalization, academic excellence, research collaboration, and the development of globally competitive universities. So welcome back to our listeners, and to you, Debbie. It definitely feels good to be back. I hope you had a good break.
Thanks, Asha. Well, as you know, we've had protests on campus which have disrupted our calendar, and that, together with the ongoing March on March protests, and also in the context of universities and the recent portfolio committee comments on the employment of foreign nationals, have left many of us unsettled on campus, and this has also reopened the debate about foreign nationals in higher education. Before we get into this context and the legal framework, Aisha, I know you've spent some time in Home Affairs offices yourself, so perhaps you can clarify for us the distinction between lawful migrant workers or foreign national workers, permanent residents, naturalized citizens, and then unauthorized or undocumented, and sometimes called illegal workers, and the significance of the distinctions.
Yeah, I think this would be the right place to start, because quite often, and as we've seen recently, as you mentioned in public media, this distinction is not quite appreciated, especially when legally each type of status means very different things. So if we start off with a lawful migrant worker, there's someone they're not a South African citizen, but they have the right to live and work in South Africa. And so they would enjoy the same rights and protections under our South African labour law. Permanent residents, however, they're a bit different. They're not South African citizens. They have been granted the right to reside permanently within South Africa. And for most employment purposes, they stand in a very similar position to citizens and don't generally require a work visa. Naturalized citizens have gone one step further. So they have acquired South African citizenship through the legal naturalization process. And so they enjoy the same constitutional rights and obligations as any other South African citizen. So then we finally have our undocumented migrants who do not have lawful immigration status or the legal authorization required to work in South Africa. Those distinctions matter, and labor law and immigration law are intersecting here to regulate status and rights and obligations. So when we talk about regulating migrant labor, we're talking about lawful employment within a legal framework and not about people who are unlawfully present in the country. And unfortunately, within the public media, the discourse often collapses all of these categories into one, which tends to create a lot of confusion. And in many cases, it fuels xenophobia rather than an informed, policy debate or discussion. And South African labor law already contains processes and protections around employing foreign nationals. So Debbie, what exactly is the concern, and specifically in the higher education context, which we've seen debated in the media lately?
Thanks, Asha. As you mentioned, of course, both labor law and immigration law are at play here. And it's the principal legislation, certainly currently, that governs the employment of foreign nationals, which is the Immigration Act of 2002 and its regulations that provide the framework for visa requirements and employer obligations. And so, of course, in the higher education context, these would have all been complied with. This legislation and these processes are administered by the Department of Home Affairs, whereas the recently proposed amendments to the Employment Services Act would expand the role of the Department of Labour and Employment. But just to get back to the Immigration Act, there are different categories of work visas. General work visas and critical skills work visas. So that's primarily what we would see being used in employment. There's also intra-company transfer visas and corporate visas. And Home Affairs provides the framework and the guidance on who qualifies for each category and how to go about applying for work visas. But the process is actually facilitated by VFS Global, or if an applicant is applying from outside South Africa, that would be through the South African embassy or consulate, and it takes from a few weeks, as I'm sure you know, to a few months. And I think the process is fairly well established. And since 2024, a points-based system has been introduced for the general work and critical skills work visas, which are the two that we would be most concerned with, based on factors such as qualifications, occupation, work experience, and who has made the job offer. So it's not clear how all of this will be impacted if and when the regulations to the Employment Services Act are enacted. Just then, in terms of foreign nationals in higher education, so South African universities have recently faced scrutiny over the employment of foreign academics there's been some heated debate during the Higher Education's Portfolio Committee hearings with universities. And unfortunately, it's created, again, that anti-foreign sentiment and unsettling concerns on campus. And in fact, the percentages in South Africa are not particularly high at all. Higher education institutions benefit from internationalization. It benefits not just the individuals or the institutions, but society more broadly, although often it may be difficult to see the public good and the benefits. But in terms of benchmarks, there's a recent report by the Times Higher Education, which we can leave a link in the episode description. But it reveals the extent to which institutions, global universities, the extent to which international staff are employed. And for universities, the institutions in the top 400, the top 200, for example, we're sitting around 18 to 20% as an average. But in fact, there are some institutions that are much higher, above 40%, above 60% even. So this is way exceeds any of the institutions in South Africa. And I think our average is around 7%, possibly a little bit higher for academic staff. So I think we should really think about what benefit we would give up if we start to limit foreign employment in higher education. Because, of course, linked to this is the issue of the national pipeline for academics. There are many young academics and colleagues who are studying towards their doctoral qualifications so that they can progress up the ranks. But often this is a long process, and doctoral students might carry heavy teaching loads. So while there is support from various programs in South Africa, there's the New Generation of Academics program. In GAP, there's the Future Professors program, but these are quite conservatively funded, and certainly they address only the tip of the iceberg in terms of the needs of the sector. So we need more. We need certainly to have these programs, but international scholars come already with capacity and expertise and can contribute also to building the pipeline. So I do have my concerns around the debate taking place in higher education and the potential negative impacts if we pursue the line of reasoning that's been advanced. What are your views on this, Aisha, and also more broadly on the public debate around foreign nationals taking South Africans' jobs?
Well, Debbie, looking at what all the statistics that you've discussed, it's given us a lot more insight. But I think, my opinion around this is that I don't think the evidence supports that conclusion that foreign nationals are taking South African jobs. Certainly in terms of unemployment, South Africa's unemployment crisis is far more complex and is obviously driven by a number of factors, slow economic growth, persistent inequality or persistent structural inequality, skills mismatches, limited investment. We have infrastructure challenges and a labor market that simply isn't creating enough jobs for the number of people seeking work, so that demand-supply conundrum. And lawful migrant workers make up only a relatively small proportion of the labor market, and many are employed in sectors experiencing genuine skills shortages or where employers struggle to recruit suitably qualified candidates. According to the audited data presented from the Higher Education Management Information System, South Africa's citizens constituted 92.26% of the post-school education workforce in 2024, while foreign nationals accounted for 7.74%. And that data indicated that the majority of foreign nationals' employees were concentrated in academic roles. Of the full-time foreign staff, 82.89% served as instructional or research professionals, with the remainder occupying administrative, technical, and support positions. And that doesn't mean there aren't legitimate concerns about labor market regulation or employer compliance. Those concerns absolutely exist, and employers who deliberately circumvent immigration or labor laws should definitely be held accountable. But it's important that we don't confuse lawful migration with structural unemployment. If anything, focusing solely on foreign national workers distracts us from the much larger policy challenges that actually need to be addressed if we're serious about reducing unemployment for everyone living in South Africa.
You're listening to the Labour Justice Barometer, and we'll be right back.
Debbie, let's talk about the Employment Services Act, and it's been described by Business Tech as marking the end of an era for employers who hire foreign nationals. What exactly is changing, and why are these amendments such a significant shift?
So, Aisha, the Employment Services Amendment Bill, of course, it's still in bill stage and it's been introduced in Parliament, but it will still go through a public participation process before enacted. But maybe just to talk about what the Act currently does and then what has been added by way of these amendments and the extent to which this imposes obligations on the employer. So currently, the Employment Services Act, it does provide a structure for public employment, employment schemes, private employment agencies, and productivity and labor market services that are intended to facilitate the uptake of employment. And what the amendments do, they will continue to operate parallel to the Immigration Act, which then regulates the right of a foreign national to enter and to work in South Africa. But the proposed amendments place substantial obligations on employers under labour legislation. And it introduces this by way of a new chapter, Chapter 3A, the employment of foreign nationals, who is an individual who is not a South African citizen, nor a permanent resident, refugee, or an asylum seeker. So those are clearly distinct categories in terms of the Act. And these obligations relate to foreign nationals rather than any other category. So what the employer will now be required to do is to really satisfy themselves that through a labour market test, which will be prescribed in the regulations, to test that no suitably qualified South African citizen is available to fill the position. And of course, that would include a permanent resident. So that there would be an increased obligation on the employer to ensure that no South African is available to do the job. And then also to ensure that a skills transfer plan is developed and implemented so that the foreign national is intended to also serve this skills transfer, skills development role and not to assume the post on a permanent basis. And then the terms and conditions of employing a foreigner must not be less favorable. Often that is the argument, that foreigners are employed on less favorable terms. So that is not permitted, expressly not permitted. And then the employer must at all times be able to verify that a foreign national has applied for a visa and is lawfully entitled to work in South Africa and perform the work for which they are employed. So what is envisaged is increased inspections. The labour inspectors, who themselves, we've mentioned in a previous episode, have been bolstered in terms of the number of inspectors. This will give them greater powers of inspection and also greater powers to impose fines for non-compliance. And then one of the controversial aspects of the Act is the Minister of Employment and Labour will have the power to prescribe maximum quotas for the employment of foreign nationals in respect of particular sectors or occupational categories or geographical areas, which is actually not too unusual for countries to place some form of restriction on the employment of foreign nationals. So how this is implemented in practice would, of course, be important. Another important factor that should, when we compare ourselves to others, is to think about how the South African economy itself was developed in terms of the use of migrant labor in building up, admittedly under an apartheid government, but the use of migrant labor was an important part of building the South African economy, and to do an about turn on the welcomeness or otherwise of our foreign nationals from neighboring countries does, of course, raise concerns. So, Aisha, I think it's time for us to perhaps wrap up and finish off with our Labour Justice Barometer question. If we are to place South Africa's current approach to the employment of, and here we're talking about lawful migrant workers, on our Labour Justice Barometer, where would you place it?
So I think I'd place it orange to red. I say orange because South Africa, as we've seen, has a fairly comprehensive legal framework because we have good, strong immigration legislation, employment legislation, and constitutional protections that do recognize the rights of lawful migrant workers, while also allowing the state to regulate migration in the public interest. And the proposed amendments also show that government is trying to strengthen compliance as well as employer accountability. But I don't think we're in the orange to green just yet. I think implementation remains inconsistent. I think enforcement is uneven. And I think all of what's been happening within the public discourse, it often blurs this important distinction between lawful migrant workers and undocumented migrants. And, with the effects of the June 30th protest and the effect of what it has caused, it has shown to fuel misinformation and, unfortunately, xenophobic or rather Afrophobic sentiment. And ultimately, labour justice requires us to hold two ideas together at the same time. We absolutely need to create more employment opportunities for South African citizens, particularly given our unemployment crisis. But we must also uphold the rule of law and protect the rights of people who are lawfully living and working in this country. Those objectives are not mutually exclusive. If we can move towards better policy making, better enforcement, and a much more informed public conversation, then I think we can actually move this issue closer to the orange-green at least. But maybe share with us your thoughts on this, Debbie.
Actually, yeah, I agree with you. I don't think the problem is created so much by our legal framework, but what is concerning is the anti-migrant sentiment and mobilization against vulnerable categories of workers, whether lawful or unlawful. The solution should really be a state-implemented one, and in the South African context, in collaboration with our neighbouring countries. I think South Africa's employment and economic crisis, it wasn't created by migrant workers, so it's very unfortunate that we've got to this point And, it in many ways neglects the importance, as I mentioned, of migrant labor in South Africa, in building South Africa's economy. And perhaps we should also reflect on how this has impacted on our neighbors and their own economies. So I really do hope that we shift to having perhaps a more dignified and informed policy discussions and resolutions, both within our own governments and political spaces, as well as at a regional level.
No, thanks, Debbie. I 100% agree with you. And our conversation on this topic is not over. So we hope to be continuing this discussion in a future episode with a special guest. But until then, please can we ask our listeners to feel free to leave their thoughts and comments, and we will see you in the next episode.
Thanks, Aisha. I look forward to that.
This podcast is not intended to constitute legal advice.